You can go, I don't have the please. Now, if it is a fresh matter, I don't have the please now. Angalia, wacha usije umepata na uangalia. So I have two. Just wait. Yes. And we'll wait for you. Why?
Yes, sir. Mr. Obeta.
Mr. Obeta.
I'm here with Mr. Mbeki for Mr. Echesa.
So you can see.
I was just addressing the court so that I can introduce our forum.
You wanted to introduce? Yes. Then you sit.
I tend to visit Mumias and document the scene of crime, and owing to the nature of investigations, it will be a complex duty which will need comparison with other agencies, like Communication Authority, which is likely to take some time, and the nature of the offenses. I have reasonable ground that the respondent may interfere with evidence, intimidate key witness, key prosecution witnesses, which I intend to use during prosecution. That the respondent have to be made to appear before this court within 24 hours, and that the time between his arrest and alignment in court, I hereby pray this honorable court to grant me 7 days to conclude the investigations while the respondent is in custody at Muthaiga police station.
Your Honor, a matter that occurred in Kakamega, why is it being brought to Nairobi? That is one thing they needed to tell you. And this is the question the court will ask itself. A matter that is of a different jurisdiction, why is it being brought to your jurisdiction? For 4 days to investigate this matter. What have they done in the meantime? Wasted 4 days by coming to Nairobi. 4 days. I want to sweeten the story and tell you the accused person was arrested. The accused person was never arrested at any particular time. He presented himself as when he was asked to. Your Honor, is this intended charge sufficient for them to come and ask for you to behold the accused person in custody? And what are their reasons? That he will interfere with witnesses. That is the first reason. It is now known law that when you make an allegation of that nature, you must come with material evidence to that effect. You must show the court. You must prove to the court.
Yes, Your Honor. Yes. You know, my phone is my personal assistant. Yes. Okay. So, Your Honor, that section, the maximum penalties are fine of 1 million. Of less than 1 million. So there is nothing, Your Honor. They are just misleading the court, which is very bad. Let them investigate the case of assault. And the case of assault doesn't need rocket science, Your Honor. You don't need to keep somebody for another 24 hours to investigate assault. You only need the person who was assaulted, the P3, and the police officer who will investigate. So which rocket science is he telling us that he wants to go to the moon, to the stars, and carry out activities in Mumias? He said, Your Honor, he said he's going to Mumias. He wants. But he has not said he's going to. Okay. I used an analogy, Your Honor. Let me withdraw that. Yeah. He's saying he wants to go to Mumias. Yes, sir. Okay. Other rights which emerge like this one, Your Honor, that the liberty of the individual is now threatened. The only province that can protect them is the court. Yes, Your Honor, with those few remarks, I wish to urge the court to reject this application in total, admit the subject to cash bail, reasonable cash bail, and then give him conditions whenever, whether he wants to report to headquarters or Ogigiri police station, he will report wherever the court directs. He will report always there faithfully until they finish they conclude their investigation. He is a former cabinet secretary. He is a man who believes in the rule of law, and he has never been violent in his life.
That this court is vested with jurisdiction to hear and determine the case, notwithstanding where the offense or offenses occurred. So, Your Honor, the police are not only investigating a case of assault, but they are investigating election offenses committed by the respondent. One of the offenses, Your Honor, is entering an election center without authority, contrary to Section 13H of the Election Offences Act. Election offenses, numerous election offenses suspected to have been committed by the respondent. And so far, Your Honor, what the IO has done is not only to present the suspect to this court today, but he has managed to record statements from some of the witnesses. So he has not been indolent on the case, Your Honor, as alleged by counsel for the defense. The offenses that have been investigated, it was impossible for the IO to finalize investigations within 24 hours as stipulated in the Constitution. And that is the reason why, Your Honor, we've not presented this court with a charge sheet, because investigations are ongoing and there's need for multi-agency collaboration. Your Honor, as soon as investigations are finalized, we shall avail the suspect the very fundamental principles of certainty of a charge, which requires that a charge must have reasonable information. Status of the respondent in the society, we feel that there is a likelihood of interfering with witnesses. That is, Your Honor, why we are seeking that he be detained until all the witnesses have recorded their statements. I pray the application is allowed, and invite counsel watching brief for the complainant to make a few remarks.
His documents, the P3s and the rest, and to confirm the nature of the injuries he sustained. Under the circumstances, as holding watching brief for the complainant, I would support the prosecution case at this juncture, that the investigations be conducted thoroughly.
So as we take long, there are some delays at times. I know you have heard about it. So we try to move as fast as it is possible. The more submissions you make in a matter, the longer it you take to do that. Thank you very much.
Junge, we, KTN. Kuja nyuma, kuja nyuma. Ya, kira dah mau wajan ni. No, kana mic.
Rashid Echesa has been brought to court. And what has happened is that the state had we anticipated that they were going to bring a charge against him. But what they brought was a miscellaneous application asking for a few more days to investigate this matter further. They are saying that it's an Elections Offence Act, which we have actually told the court, the section 65A of Act number 24 of 2011 does not clearly show that he could have committed that kind of an offence, because that's an offence whereby somebody has been charged with trying to force somebody to vote for an individual. So you can see all these things, what they're doing at this particular moment is they're fishing. So when they're coming to ask for 7 days, honestly, do you think this is fair? Don't you see the hand of the government in this? How can you come here to ask for 7 days to investigate an assault and spend 4 days on the road, bringing him from Kakamega to Nairobi and keeping him in custody? For 4 days are wasted and they come and ask for 7 days. We have made an argument as to why we are opposing that application, and we are the court has heard us. It will be giving a ruling on that matter. But quite clearly you can see that when a matter has been removed from its jurisdiction, whereby they say allegedly the offence occurred, which is in Kakamega, and brought to Nairobi, anybody can see quite clearly that there is pressure being brought to bear on the suspect. Why? Because he has this antagonism with the government? Why? Because they do not like him anymore? Why? Because he does not support them anymore? All these are questions that we need to bring about. And then that's when you will see that there is total unfairness in this. A simple assault case, if it was an assault case, and we are saying, as far as we are concerned, when you are removing a mask from somebody's face and you want him to speak clearly, it might look like an assault. Let me just say that. So we are not even having an assault in this matter. It's somebody's mask being removed and so that he can express himself clearly. Did you even see the person flinch? The person stood there. We have no problem.
That even if we have dictators like Matiang'i who think they are above the law or they are a law into themselves, we know that the law and the constitution will protect us from such a people. Because we have seen many people with a lot of powers, but they come and go. The constitution will be there for a long time. So let us follow the rule of law and due process. This business of moving Rashid from everywhere and taking him around, the instructions came from Arambe House. And we know who gave them. It is Matiang'i. We are not going to beat about the bush. Yes, because Matiang'i spoke somewhere where he said, he mentioned him indirectly. And we are saying Matiang'i should not think he's above the law. He must operate within the four corners of the constitution. Kenya is governed by the rule of law and due process, not by dictatorship, no matter who you are. Because tomorrow you will not be a cabinet secretary. Yes, so that is what we are saying. As lawyers, we protect the rule of law and due process. We are faithful to the constitution, and that's what we want everybody to do.
It's the scale upon which the criminal justice system has been used for victimization of opponents. You were just attesting that you probably saw the clip. If you were looking clearly also, you must have seen a myriad of other clips of where unwarranted violence was meted across board. But no action is being taken, assuming that we are to say that the law is blind, the law is impartial. And therefore it is a dark reminder of the Nyayo days. We have had a new constitution that Uhuru's government is extremely uncomfortable with, and is perpetuating a scheme of erosion of that constitution by using the criminal justice system to victimize opponents. It can be done to you, it can be done to anybody. Kenyans think it is convenient now, just a mere charge. Today they are coming here to ask for pre-charge detention for a further 7 days, a total affront, a harassment of political opponents. But one of the things that has also happened, sadly, apart from the affront by the Constitution, is the way the DCI office has been derogated in terms of its impartiality and credibility by one Mr. Kinoti. It is sad that a new constitution that midwives an office of the DCI is given to a villager who then totally erodes its neutrality, its impartiality, and its constitutional role and mandate to pick on and harass political opponents, to a point where even at some point there was a stalemate with him and the DPP. The DPP, guided by God and the Constitution and conscience, put a gag on Kinoti. We want courts and other Kenyans now to put a gag on Kinoti. We're asking officers of Kinoti to put a gag on his harassment. These are fellow Kenyans. You must not use these systems to perpetuate an injustice against any other Kenyan or fellow Kenyans. We are ready for it. We know that Uhuru has become extremely desperate. He will fight this because he wants to retain a dictatorship. He wants to protect his wealth and ill-gotten wealth over the period of time. He realizes that there might be accountability that might rain on him and his vast family interests, and therefore is trying to manage the succession. But I think the Kenyan people are wiser. They will vote in the best manner to ensure that they secure their future.
Base yetu yawaletea Shujaa wa Base Pool Table Championships Meru Edition. Tuma wachezaji wawili gwiji kutoka base yako. Tarehe 8 hadi 14 Machi mwaka huu na mshinde hafamili 200k ama 100k. Ni tarehe 8 hadi 14 Machi mwaka huu pale Gitoro Conference Hall Makutano. Vunja weka wa. Dial *483*8888# kuregister base yako.